how a dying declaration is made. What if the dying declaration is made in order to get revenge? New Year's coming up. Parties, festival-like celebration, making resolution. Is it all what comes to your mind? But can you imagine the plight of a girl who was gang raped on New Year? Hello everyone, this is Farhat Naeem and you are watching India Legal. A young lady of 24 years old committed suicide on January 7, 2004 after she was gang raped and tortured by her boyfriend Sajal Jain and his friends. Sajal Jain, who was 32 and father of 2 children, befriended this young lady. On December 31, 2003, he invited her to Hotel Ashok Palace in Ahmedabad to celebrate the New Year. There, he raped her along with 4 of his friends. The young lady left a suicide note behind where she named Sajal and his 4 friends for raping and torturing her. Now, Sajal Jain is son of S.K. Jain, who is an industrialist and owner of Delhi Apollo Millennial Hospital. But Sajal was arrested on charge of rape and abetting suicide from Apollo Hospital in New Delhi, where he was admitted in ICU claiming to have food poisoning to try and evade his arrest. But they were arrested based on a suicide note. So, is suicide note considered as dying declaration? First, let's understand what a dying declaration is. The concept of dying declaration comes from the maxim Nemo moritus presumitur mentire, which means a man will not meet his maker with a lie in his mouth. This declaration is also called later mortem, that is, words said before death. In layman's term, a dying declaration is a declaration or statement made by the person who knows that his death is coming. This has great significance in the court of law, as it leads to some serious accusations against the defendant. Dying declaration is defined under Section 32 of the Indian Evidence Act, which states that when a person makes the statement so as to cause of his death or as to any of the circumstances of transaction which resulted in the death, in cases in which the cause of the person's death come into question, such statements are relevant whether the person who has made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. Section 32 is an exemption to rule of hearsay and makes admissible the statement of a person who dies, whether the death is a homicide or suicide, provided the statement relates to the cause of the death or relates to the circumstances leading to the death. In this respect, Indian Evidence Act, in view of the peculiar condition of our society and diverse nature and character of our people, has thought it necessary to widen the sphere of Section 32 to avoid injustice. Now, the question comes, how a dying declaration is made? Can it be made through writing, orally, through actions, or in the form of narration? The answer is yes, but it is preferred if it is made written in the vernacular which the person who is making the declaration, he understands and he speaks that language. There are certain factors to be kept in mind while recording the dying declaration. Recording by a judicial magistrate. If the victim fears that his death is impending, and if the police officer also believes that the victim would not survive till the trial, they may apply to the Chief Judicial Magistrate for recording the dying declaration. Declarant should be fit and conscious before making the statement. In case where recording is done by a police officer or the medical examiner, they should mention the state of mind of the victim at the beginning of the recording. The declaration should not be concerned with someone else's death but one's own. There should not be more than one declaration, as if they contradict each other, the declaration would lose its value. The statement should not be based on influence or coercion and should be spontaneous. The mental and the physical fitness of the declarant plays a crucial role in admissibility of the dying declaration. In Kaushal Rao versus State of Bombay, the Supreme Court of India ruled that dying declaration could form the sole basis of conviction, provided that the mental capacity of the declarant at the time of declaration and corroboration of the circumstantial evidence with the statement has been cautiously scrutinized before decision making. But What if the dying declaration is made in order to get revenge? The Law Commission of India in its 185th report mentioned that it has however been accepted in India that there is a tendency among the person dying to implicate all their enemies who have or may have nothing to do with the offence. In Panilal versus State of Gujarat, the Supreme Court of India, in particular reference to the psychological status and mental capacity of the deceased, held that this court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting or imagination. The deceased had opportunity to observe and identify the assailant and was in fit state to make the declaration. In the case of V. Venkatraman versus State, the High Court of Chennai held that if a lover commits suicide due to love failure, if a student commits suicide because of his poor performance in examination, if a client commits suicide because of his case is dismissed, the lady, the examiner, lawyer respectively cannot be held to have abetted the commission of the suicide for the wrong decision taken by a coward, fool, idiot, a man of weak mentality, a man of frail mentality. Another person cannot be blamed as having abetted his commission of suicide. In the case of State of Maregoda, it was held that a suicide note is also considered to be evidence under Section 32 as a dying declaration. In recent years, Section 32 of Indian Evidence Act has helped various victims get justice, such as Nirbhaya gang rape case, Hathras gang rape case, dowry death cases, etc. The admissibility of dying declaration no doubt raises question in certain cases where the accused is actually innocent. But as every coin has two sides, this doesn't allow judiciary to ignore the dying declaration as a piece of crucial evidence. Thank you everyone. Kindly like and share our video, and if you want to watch more videos like this, subscribe India Legal.